Introduction to Law, Writs and Jurisdiction. General definition of a writ. General meaning. A formal written order issued under seal, in the name of a sovereign, government, court or other authority. It commands an officer or other person to whom it is issued to do or refrain from doing some act specified therein. Constitution of Pakistan. HC. Writs are issued by the High Courts under Art. 199 of the Constitution for the enforcement of fundamental rights, for the redress of any other provision of the Constitution or any provision of any statute, ordinance, order, rule or regulation or illegality by any authority. Constitution of Pakistan. SC. Article 184, 3. Of Constitution confers power on SC to make an order like by HC in exercise of its writ jurisdiction under Article 199, where it considers that a question of public importance with reference to enforcement of any of the fundamental rights guaranteed by the Constitution is violated. Types of writ. 1. Habeas corpus. 2. Mandamus. 3. Prohibito. 4. Certiorari. 5. Procedendo. 6. Quo warranto. Habeas corpus. Habeas corpus means, you may have the body. Habeas corpus is a legal action through which a prisoner can be released from an unlawful custody or detention. The remedy can be pursued by the prisoner or by another person coming to her assistance. Habeas corpus originated in the English legal system, has historically been an important legal mechanism, protecting rights of individual against arbitrary governmental action. A person, when arrested, can move the court for the issue of habeas corpus. It is an order by a court to the detaining authority to produce the arrested person before it so that it may examine whether the person has been detained lawfully or otherwise. If the court is convinced that the person is illegally detained, it can issue orders for his release. The application can be made by the person illegally detained or in certain cases by a person on behalf of the prisoner, e.g. friend. Relative. Writ of mandamus. Mandamus is a judicial remedy which is in the form of an order from a superior court to any subordinate court, organizational or public authority. Simply, it is a writ issued to a public official to do a thing which is part of his official duty but he has failed to do so. It cannot be issued to force an authority to do something against any statutory law. Writ of certiorari. Literally, certiorari means to be certified. Legally, it is a writ intended for seeking judicial review. It is an order by a superior court to a lower court, tribunal, or public authority to submit the record in a certain case for review and proper consideration. Writ of procedendo. A writ of procedendo is a remedy where there is a delay in rendering a judgment that amounts to abandonment or denial of justice. It is an order of a higher court to lower court, directing that court to extract a delayed judgment. The writ does not specify as to what judgment the lower court must extract. It merely orders the lower court to proceed to judgment. Refusal to comply with the writ may subject the lower court to contempt. Writ of prohibito. Writ of prohibito means to prohibit or to stop, e.g. stay order. The court may issue a writ of prohibition to prohibit the authority from acting in excess of its jurisdiction. This writ is normally issued by a superior court to the lower court asking it not to proceed with a case which does not fall under its jurisdiction. Writ of quo warranto. Literally means, on what authority one is holding the public office. The writ of quo warranto is issued against a person who claims or usurps a public office. e.g. a person of 62 years, appointed fill a public office, whereas retirement age is 60. HC has a right to issue writ quo warranto.